Hi, good evening, everyone. I'm Rajeshwari, a chartered accountant, cost accountant, and a company secretary. We will continue with the Limited Liability Partnership Act. So, in today's session, we will be learning what are the incorporation, how to incorporate, and what are the procedural formalities further. So, when I want to incorporate an LLP, first I said that I should have to reserve my name. So, that should be made available to the applicant. So, for that, one needs to fill run LLP, reserve unique name for LLP. So, this run LLP is you are reserving the unique name. That is how to make it available. So in that, for that, you should have to fill the form and you should have to submit it to Argos. So once you make it, then you can, the step one, see, these are the various steps. So when I use the word steps, the order should have to be followed. So first you make available the name, and then you start incorporating an LLP, the new LLP. So therein you can specify who are all going to be the partners, designated partners, filing their consent, and so on. That can be given. Then third step is you have to execute the LLP agreement between the LLP and the partners, and that should have to be filed in E-Form 3 within 30 days. So first run LLP, then you are filing E-Form filler, FILLIP for incorporating. And the third step is executing this agreement and submitting it with the Argos. That is the next step. When we ask about the partners and their relations, so who are all on incorporation of an LLP? So whoever partners, it is a new LLP which has been incorporated. So whoever persons who have subscribed their names, they will be the partners. And other partners can also become a partner of that LLP subsequently in accordance with that LLP agreement. So LLP agreement will specify, if they want to specify what will be the maximum partners, they can specify anything in that LLP agreement. So subsequently, the other person may also become a partner. So first you become a partner by subscribing your name to the incorporation agreement, and subsequently also a partner could be admitted, a partner could cease to be a partner. So that is also possible. So this is with regards to partner and their relations. Now we'll see what is the relationship of partners. So first one, we have read that Schedule 1 of the LLP Act specifies the mutual rights and duties of the partners. So it is not only the mutual rights and duties of the partners of LLP is also specified, and between the LLP and the partners. So even that is specified by the LLP agreement. Then whatever there is a change, that change is also specified, and that should be filed in Form 3, we read before. And you have to pay the requisite fees in the MCA portal and you can file it. And whatever you have made, that agreement should be in writing and between the persons. That may also impose, that agreement may impose an obligations on the LLP. And if the impose obligations, that agreement should have to be ratified. Ratified means agreed upon by all the partners after incorporation. If any obligations are being specified, it is an unanimous consent ratified by all. So all the partners of the LLP agreement should have to consent for the change or the obligations. Suppose there is no agreement. In the absence of agreement, the first schedule to the LLP Act will be the determining thing. And for whatever proviso or any point is not specified in that agreement, we know that the first schedule will be made applicable. So whatever matters are set out in the first schedule, that will be applicable. So mainly the agreement should have to be written. It should have to be submitted to the registrar, and the partners should also agree to it, and the mutual rights and duties are specified in that agreement. Right? In case of cessation of partnership, now a partner, I'll tell you. See, in case of cessation of partnership, a partner ceased to be a partner. So in that case, in accordance with that agreement, it may provide, or at any time he may cease to be a partner. He can resign from his partnership. He can go away from being a partner. For that, he should have to give a notice in writing, and of not less than 30 days to the other partners also of his intention to resign as a partner should have to be given, because the other partners are only going to be there. He should have to intimate that he is going to resign, or you can say, instead of notice, you can also say that he should have to intimate other partners that he is planning to resign. So 30 days in advance he should have to say. And here it is may cease. This is an optional. Here it is compulsory. Shall cease. So it is mandatory. Or it is compulsory. So first one, it is an optional. The partner may cease to be a partner. In the second proviso, it states where shall cease to be a partner. So definitely he ceases to be a partner if he dies, or the LLP is dissolved, or he becomes an unsound mind and he was declared to be of unsound mind by a competent court. Then he has applied to be adjudged as an insolvent or declared as an insolvent. So in all these cases, it is mandatory. In all the three cases, it is mandatory or compulsorily he ceases to be a partner. Right? So that's why you have a wording may, and here it is shall cease to be a partner because of some disqualification, or he cannot continue to be a partner. Once he becomes a person of an unsound mind or he has become insolvent, he cannot continue as a partner. Then, when a person has ceased to be a partner, after he ceases to be a partner, then he is called as the former partner. He is no more a partner. So that former partner will be regarded as a partner unless you should have given the notice. So for others, you have not given the notice. So still, till a proper notice has been given. So unless, the word starts with unless. So the former partner will be a partner except in all these two cases. That is, he should have given the notice that he is no more a partner and to the other partners, and the notice has been given to the registrar. So in those two cases, he will not be construed as a partner. He is no more a partner. In other cases, if this notice is not given, or notice has not been delivered to the registrar, he will be considered as still continuing with the partnership in the LLP firm. Then whatever it does not itself discharge the partner from any obligations which were incurred while he was a partner in the LLP. So which he incurred while being a partner, whatever obligations has been taken. So he is liable for those obligations. So the former partner is liable for the obligations entered into while he was a partner, even though he has ceased to be a partner. That is it. he has ceased to be a partner, then what are his rights? He can get back the capital contributed, an amount he is entitled to receive. Whatever capital he has contributed, that he is entitled to receive. An amount equal to the capital contribution. And not only that, in the accumulated profits, whatever is the share, that can be taken, of course, after deduction of the accumulated losses, if any. So he is entitled to receive, it is more of his rights of a partner, retired partner. Then a former partner, not when in case of death of a partner, his legal representatives are entitled to receive that. So a person entitled to his share on the death or insolvency of the former partner, the legal representative or official receiver or assignee is entitled to it. But the third party cannot interfere in the management of the LL. So the third person or whoever it is, that person has got no right to interfere in the management of LLP. They can only get the proceeds or whatever is the that is retired partner is entitled to receive either the profits or the capital that can be received. Other than that, they shall not have any right to interfere in the management of the LLP. That is not possible. Shall we proceed further in registration of changes? If there is any change that has taken place, that should have to be intimated to the registrar. So they should have to intimate a partnership. A partner has changed his address. So he should have to intimate the LLP within 15 days. Then after that 15 days, this LLP will give to the registrar within 30 days. So the partner should have to specify to the LLP within 15 days and LLP should have to intimate the registrar within 30 days about the change. Whatever change in address, it could be the change in address or name or address of a partner. So all those things they should have to file with the registrar. So every partner shall inform the LLP of his change. See, it starts with every partner shall inform. Whenever the change takes place, he should have to intimate it. That is the meaning. So whenever any change takes place, that partner should have to intimate it to the LLP within 15 days. Either he has changed his name or address, that should be intimated. The LLP in turn, whether he becomes or ceases to be a partner, they should have to file a change. So when changes, what are all the changes? First, it talks about the partner's change. Then second, it talks about that person should have to intimate the change, whether he becomes, when he is admitted as a partner or he ceases to be a partner. Both should have to be intimated within 30 days of the change. Not only that, when there is a change in the name or address of the partner, that should also be intimated within 30 days. So it is any change should have to be intimated by, this talks about the partner admission or retirement. The second thing talks about the changes in the name or address of partner. Both should have to be intimated to the registrar. So in which form you will find it? In such form and accompanied by such fees. I've given for your reference, it is form 4. You need not remember it. But just for procedural complaints, we do it. It is form 4. and it should be signed by the designated partner because he is the person who's responsible for complaints, right? So it should be signed by the designated partner as he is responsible for complaints and authenticated in the manner specified. Now, whatever authenticated, it should be, can be signed by the digital signature or whatever is the procedural formalities that has to be complied with. Now, I said changes has to be intimated. Now, when an incoming partner comes, then he should have to give his prior consent, right? We read about this prior consent to act as a partner. So that consent should have to be filed with the registrar. So if it relates to an incoming partner, it shall contain a statement by such partner, that is that incoming partner, that he consents to become a partner, signed by him and authenticated in the manner provided. If the LLP contravenes, doesn't follow the provisions, doesn't intimate the change, then the LLP and every designated partner is liable to a penalty of 10,000. If the partner does not give, it is his duty to give. He has contravened the provisions. He has not done his duty. So in that case, non-compliance, for that non-compliance of his duty. So for that it is 10,000. And this is for LLP and DP. This is for the partner. Now, there is an option given. Suppose a person ceases to be a partner, he himself can also file with the registrar. That provision is also there. Suppose he believes that LLP may not file his, that he has ceased to be a partner, then he can also file it. In that case, what our registrar will do, will get a confirmation from the LLP whether it is so. They should have to get a confirmation because only the file is filed, that is the form is filed only by the LLP. Now the partner gives does a filing, so the registrar will get it confirmed from that LLP whether it is true or not. So to that extent, he should have to obtain a confirmation. So the partner may himself file the notice. Then if he has a reasonable cause to believe that LLP may not file the notice, then the registrar shall obtain a confirmation. Suppose the registrar is not able to get a confirmation from the LLP, then it will be treated that it has been complied with within 15 days. If he is not receiving any confirmation from the LLP, then he shall register the notice made by the person that he has ceased to be a partner, that confirm that he can register within 15 days. So he will wait for 15 days to get it confirmed, to get the confirmation. Right? So we saw that first one, name or address. Then after admitting a partner or ceasing to be a partner within 30 days, then that notice should have to be filed with the registrar in such form and such manner by paying the fees. The incoming partner should have to get his consent, that he should have to give a statement. That statement should also be filed with the LLP. Any contravention for the LLP and DP, it is 10,000 rupees, and for the partner, individual partner, it is 10,000 rupees. And a person who ceases to be a partner can himself also file with the registrar. And the registrar can wait till 15 days for getting the confirmation. If no confirmation is received, he can register the notice. So this is with regards to changes in partners. Yes. No, when the partner ceases to exist, he can specify from which state he wants to exist. That is, he wants to cease. Suppose today there are two options. I can say on 19th that I will be working as a partner only till 30th November. So I can give an intimation. So I will be a partner till 30th November, and after that I will cease to be a partner. That is possible. Or in an emergency, you should have to, they cease with immediate effect also. Then it will be taken by the LLP, that notice will be given, then they may accept it. Or they may say, no, this can be accepted. You continue till another 5 days, they may say, or till 25th you continue. So you discharge your obligations and responsibilities, and then it will be taken effect with that. So that way also, mutual agreement, it will be agreed upon. So he will say, okay, with effect from that. So if the date has been specified in advance, he has given, from that date it will have effect. So with effect from, that will be specified generally to avoid all the confusion. So the mutually it will be agreed between the LLP and the partner. But mandatorily, if he becomes insolvent, then automatically he ceases. That is there. He cannot continue as a partner. Then in subsequent provisions, we will be seeing one more thing which we will be seeing later. So what is his duty? And as an agent, what is his thing that we will see? So partner as an agent, he is one thing. He is an agent of the LLP only. And he is not an agent of the partners. Of the other partners. He is only the agent of the LLP. Yes, resignation of partner is similar to a normal resignation. Yes, he resigns from the partnership. Yes. He was willing to admit to become a partner. Now he doesn't want, so he ceases to be a partner. So it starts with every partner. You have to read like that. Each partner, every partner, what is the wordings used in that section? Every partner of an LLP, for the purpose of the business of the LLP, is the agent of LLP, but not of other partners. And one thing, the LLP is also not bound. If a partner does something, the LLP is not bound. If you have got an authority, say for example, for a particular act, you can restrict this partner is entitled to do these acts, act number 1, 2, 3. This partner can do this act. What is his authority? That will be specified. Suppose he has not given an authority and he does that particular act, then the LLP is not liable because he has acted outside his scope of authority. So when he has acted outside the scope of authority, when the partner has no authority and he has acted in doing a particular act, so he has acted outside his scope, then also LLP is not liable. Then the third party knows that he has no authority. He knows that he is not a partner, he is not aware that he is a partner or does not believe him to be a partner, then also the LLP is not liable. That is the meaning. So the person knows that he has no authority because only one person files the complaints. If the other person files it, then definitely he has got no authority. So by the routine normal working, the other person knows that he has no authority, or he does not know that he is a partner. That information itself is new. He was not aware that he was a partner. So even in that case, the LLP is not liable. And the third person does not believe him to be a partner or connected with LLP also. Even in that case, the LLP is not liable. That is the meaning here. Yes, a resigned partner can join as a partner. So even for that, the changes should have to be specified. See, if the resigned partner, today he resigns, say after from January 1st, he wants to become a partner. Yes, he can join. Yes, I will repeat this. See, a third person is entering. See, this, the second section 27 talks about when the LLP is not liable. When first one, when the partner acts outside his scope of authority. Then also then in that case, the LLP is not liable. The third person knows that he has done some act with the third party. The third party does not know him to be a partner of this LLP. See, ABC LLP is there. Now A is there. Now a third party X does not know that A is a partner in ABC. So in that case, this LLP is not liable to this third party for any act done by this A. Or the third party knows that A does not have the authority. Now, the third party X knows that A has no authority to do this act. Then, if A does that, even then, the LLP is not liable. Is it clear, ma? Now, so this talks about the third party. See, a person can say, no, the LLP is only liable for any acts done by the partner. So the third party cannot say when he has acted outside his scope. That is, the law relieves the LLP from the liability for any act done by the partner with the third party. That is his botheration. The LLP is not in any way responsible. So the liability of responsibility, there is a limit, has been enforced because it cannot be held responsible for any act done by the partner in his personal capacity, right? For behalf of LLP, if he has done something and the LLP is bound to the third party. So whatever he has done, LLP is not responsible. That point has been specified in section 27 of the LLP Act. It says extent of liability. To what extent the LLP is liable for the thing. So see the wordings used, extent of liability. To that extent only, if he has within the scope he has done, then yes, the LLP is liable. So LLP is not bound by anything done by a partner in dealing with a person. If the partner has no authority in dealing with a person. So this is that person. So it is between the A and the third party. That is the concept. LLP is liable when it is liable. As a result of wrongful, if a partner of LLP is liable to any person for a wrongful act or omission on his part in the course of the business of the LLP, or if he has acted within his authority, or so when he has acted within his authority, then LLP is liable. In the course of business, in the normal course of business. So he has not done anything outside his scope. So in the course of business, that is the key word. In the course of business of the LLP or with its authority. If anything has been done, any wrongful act or omission, then the LLP is liable to any person. Suppose there is a false statement given, then the LLP is liable. Or a important thing has been brought out, then LLP is liable in the normal course of business. Then it is liable. An obligation of an LLP, whether arising in a contract or otherwise, shall be solely the obligation of the LLP. Whatever it has incurred, the liability, that liability will be met out of its property. Suppose it is paying a penalty or it is paying a fine, then in that case, out of the property, it is paid. Paid out of the property of the LLP. That is the concept. So when they talk about the extent of liability of LLP, section 27 speaks about that. Where LLP is liable, where LLP is not liable. Or I can ask you a question. What is the extent, the liability of LLP? Examine. If I use the word examine in the question, examine the liability of LLP. You have to say when it is liable, when it is not liable. Both should have to be specified. That is the meaning of the word examine, both the pros and the cons. Where it is liable, you should have to read the question carefully in law. What portion or what provision has been tested? Or if they give you a case study and then if they ask you, then you can give a reply, you can explain the provisions and you can conclude. That is possible. Then, now 27 talked about LLP's liability. Now it is the LLP, if it is the liability of the partner. What is the extent of liability of the partner? So that you should have to remember. Let me write it. Section 27 talks about the extent of liability of LLP. Then 28 talks about liability of partner. So when he is liable, when he is not liable. He is not personally liable, directly or indirectly, for an obligation referred to in subsection 3 of section 27. So arising in the contract or otherwise, that shall be solely the obligation of LLP. So here, the partner is not liable. So referred to in subsection 3. So here, the LLP is only liable. So here, the LLP is liable and hence partner is not liable. Because he is a partner, he is not liable for the obligation, whether it is taken directly or indirectly, he is not personally liable. That is the first provision. Then second, the provisions of section 27.3 and 28.1 shall not affect the personal liability for his own wrongful act or omission. See here, he has given no. LLP is liable. It is done in the ordinary course of business. But if he has done outside his scope in dealing with the person, for that LLP is not liable. So the partner is liable for his own wrongful act or omission. But a partner shall not be personal liable for the wrongful act of any other partner. Meaning, if he has done, A has done anything wrong, a wrong act, then A is liable. For the acts done, wrong act done by B or C, A is not liable. For his wrongful act, see, for his own wrongful act. This is the key word. For my wrongful act, I am responsible. For your wrongful act, I am not responsible. So this is the key word. So that will only specify that you have understood the provision correctly. So a person is liable for his own wrongful act or omission, but he is not liable for any wrongful act or omission done by other partner, because he is for his action only he is liable. He is an agent of LLP. He is not an agent of the other partners. We read it. So that is the concept which has been. He is an agent of LLP, but not an agent of other partners. So he is not liable for anything done by the other partners. That is the concept. So for his own wrongful act, it is very important. If you write it for wrongful act or omission, you will not get marks. For his own wrongful act, that is very important. Then, holding out, partner by holding out. Holding, so what does it mean? So whether by outspoken words spoken, or by his conduct, he represents himself to be a partner in that LLP, or he permits himself to be represented as a partner in that LLP, then based on that belief, some third party has done something, or given the credit, or a bank would have given a credit. For example, a financial institution would have given the credit that he has a partner. So who has given the credit based on this representation, then he is liable to that person. Because based on that only, the other party has rendered some transaction, entered into a transaction with the LLP. So who has, on the faith of any such representation, given credit to the LLP, whether the person representing himself or represented to be a partner does or does not know. See, this partner may or may not know that it is because of his representation, the financial institution or the bank has given credit. Still, he is liable. Whether he knows it or not, that is immaterial. But based on his words spoken or written by contact, some third party has given credit to the LLP, the partner is liable. Any person, even he need not be a partner. So based on that, then he becomes, that is a partner by holding out. It is not saying any partner. Read the word. It is any person. It has not been specified as any partner. No. It is any person. You have to write it clearly. So any person who has, he might be a partner, he might not be a partner. Does or does not know based on his words spoken or written or by contact. So either it could be by words spoken or written statement he has given, or by his contact. You have this partner by estoffel, right? Same case here in LLP. He is acting like a partner. That's why the wording used is, it's not any partner, it is any person. So if they ask you a question, you should have to write any person. If you write it as any partner, that means the understanding is not complete. You have not understood the concept. So any person, each and every word in law, you should have to read every word, word by word. So every one is a point. He is liable to any person. That's why I put it in bulletins. Is liable to any person who on the faith of such representation has given the credit, whether the person representing himself or represented to be a partner, whether the person representing himself are represented to be a partner, does or does not know that the representation has reached the person so giving credit. So you are responsible as a partner by holding out. But however, so what is that however? Where any credit, however, where any credit is received by that LLP. So it is the recipient, no, some recipient of the benefit. Yes, I will tell you. I'll give you an example. Suppose the financial institution has given 10 lakhs loan to LLP. That is a thing, it has extended the financial credit, or he has given a loan, or any credit has been given by the financial institution. Then all those things, it is because of this partner. Say if a popular person is a partner, then because of his nature, bank or they may extend a credit. An ordinary LLP, they may not get the benefit. So because he is a partner, reputed person, so he becomes a partner. Then the person may extend the credit. No, the third person may give a credit. No, so that is being specified here. So, however, where any credit is received by the LLP as a result of such representation that he is a partner, because of that only the credit has been given, then the LLP shall, without prejudice to the liability of the person so representing himself or represented to be a partner, now it has received the financial benefit, no? To that extent, it is liable. For the credit, for the loan given, see, the third person has given a loan. Then the financial institution has given a loan to the LLP for 10 lakhs. Then it is the duty of the LLP to return back the amount or pay interest, whatever it is, has been agreed upon. That should have to be done by the LLP. No, if it is given, if the loan is given to a partner, that is separate. You see, this has got a legal entity. You are giving a loan to a partner is separate. This LLP has got legal entity, separate legal entity. It is a company, it is a body corporate. Loan given to a LLP is separate, loan given to a partner is separate. That is his personal dealings. For the LLP, if he has a financial institution has given, the LLP is responsible. So the LLP is only responsible. So the financial institution has given some loan, the LLP should have to repay. So that is his obligation. Whatever it has received, whether that the partner has represented, that is a different issue. But it has got some benefit, no? So for that, it is liable to repay or whatever has been agreed upon, any financial benefit derived, for that, the LLP should have to give it. You can even say that he has given acted as a guarantor. Yes, any thing that I am a partner there, so I guarantee you give the loan. So based on that words only, the LLP is given a loan. Even you can take it. Even that is a representing himself. So the LLP is liable for the financial benefit derived. Then, if the partner dies, where after a partner's death, the business is continued in the same LLP name, the continued use of that name, ABC LLP, C dies. So C is no more a partner, shall not by itself make the legal representative or his estate liable for any act of the LLP done after his death. So after that death, if they uses the name A, B, C are there, C dies, then after C's death, the legal representative is not liable. shall not by itself make the legal representative. So the legal representative not liable after partner's death. That is the concept. Of course, they can use ABC. Just because they use ABC, it doesn't mean that legal representative is liable for the LLP or for the third person after that partner's death. That is the concept. Shall we proceed further? Unlimited liability. See, generally it is a limited liability partnership, LLP. But when it is unlimited liability, what are the instances? When fraud is there, then it becomes unlimited liability in case of fraud. So in case of fraud, in the event of an act carried out by an LLP or any of its partners, whether it could be done by LLP or any of its partners, for what? To defraud the creditors or any other person, either to defraud the creditors or any other person or any fraudulent purpose. Then in that case, the liability of the LLP and the partners who have acted with intent to defraud creditors or for any fraudulent purpose, then in those cases, these two persons' liability is unlimited for all or any of the debts. This is unlimited for all the debts or liabilities or for any of the debts or liabilities. So unlimited for all or any of the debts or other liabilities of the LLP. So it is the LLP and the partners with an intention, that intend to defraud creditors. That should be there, creditors of the LLP or any other person. If it is done for any fraudulent purpose, then the liability is unlimited. However, so when they use the word however, this is an exception. In case any such act is carried out by a partner, the LLP is liable to the same extent as the partner, unless it was done without the knowledge or authority of the LLP. So LLP is equally responsible or liable unless, except or unless it was done without the knowledge of LLP or authority of the LLP. So only in these two cases, the LLP is not liable. So this acts as an exception where LLP is not liable. So in these two cases, the LLP is not liable. Generally, it is liable. So that is the concept here. Then, whoever was knowingly a party. So whenever there is a fraud committed, then the punishment is also more. Shall be punishable with imprisonment and fine. Because it is a fraud, it is imprisonment and fine. So 5 years maximum 5 years imprisonment, and fine which shall not be less than 50,000, which may extend to 5 lakhs. So the fine might be minimum 50,000, maximum 5 lakhs for the fraud. Plus it is and imprisonment and fine. Then where an LLP or a partner or designated partner or employee, here the employee is also given. This is the peculiarity. Partner, TP, and you also take employee also has conducted the affairs of the LLP in a fraudulent manner. Then, without prejudice to any criminal proceedings which may arise for any law, under any law for the time being in force, the LLP is also liable, and any such partner or designated partner or employee, all the four are liable to pay compensation. To whom? To any person who has suffered such loss or damage by reason of such conduct. So 4 persons are responsible. Who are they? LLP, TP, partner, then employee. All the 4 are responsible to the other person who has done it. However, so this is an exception when it is not liable. So this is an exception. Shall not be liable if any such partner or designated partner or employee. So leave out this, the other 3 persons. The DP, partner and employee has acted fraudulently without knowledge of the LLP. So it removes the liability of the LLP. They have done, but it was without the knowledge of the LLP. So in that case, they are not liable. LLP is not liable. Right? So we will just quickly go through this. In case of unlimited liability, in case of fraud, when fraud has been done by LLP or partners with an intention to defraud creditors or any other person, then the liability of the LLP and partners shall be unlimited. Unlimited for what? For all debts or any of the debts or liabilities. That is point number 1. Exception is provided if the LLP is equally liable, but if it is done without the knowledge or authority of the LLP, it should have to be established, then the LLP is not liable. Unless it is established that. If it is established that the act was done without the knowledge or authority of the LLP, then the LLP is not liable. That is the concept. See, in practical cases, they are not a party to the fraud. That should be specified. How fraud happens without the knowledge of LLP means the partners have done it, but it was without the knowledge of the LLP. That has to be established. I am not a party to it. So that should have to be established. So the proof of burden is on the LLP to establish that it was not a party, it was done without his knowledge or authority. So that you call it as proof of burden. On LLP. To prove that it was done without the knowledge or authority of the LLP. Then, whoever is knowingly the party, they are punishable with imprisonment and fine. Minimum fine is 50,000 and maximum fine is 5 lakhs. Imprisonment, maximum years has been specified, that is 5 years. However, where it is done by LLP or partner or designated partner or employee, they have to pay the compensation. They are liable to compensation to the third party for the loss suffered. So they have to pay the compensation. But LLP is not liable if these three persons, that is DP, partner or employee, has done without the knowledge of the LLP. Right? We shall proceed further. Whistleblowing. So what is the concept of whistleblowing? See, if the partner has given some useful information for during the investigation of the LLP, or because of his information, it was solved or it was helpful in arriving at a result, or if it was information was very useful. So in that case, the court or the tribunal may reduce or waive. Reduce means it can reduce the penalty. Waive means totally it can say no penalty, any penalty leviable against any partner or employee. So, and what are the situations? Such partner or LLP has provided useful information during investigation. When any information given by any partner or employee leads to LLP or partner or employee being convicted under this act or under any other act. So he has given an information, useful information. So first point, useful information is given. Because of that, it leads to LLP or partner or the employee convicted of an offense under this LLP Act or any act. Then in that case, if it is so, then the court or tribunal, who can do it? The court or tribunal may, it is only may, it is not must, may reduce or waive any penalty leviable. Right? So because a person has given this information, that employee has given this information, because you were asking, no, how the other party will know about it, or that was the case in Enron scandal or that scandal coming out, right? So the employee knows, or he can say that this activity is being carried on, so he can inform. So in that case, because of his information, the company or the LLP should not take any action against that person. So partner or the LLP, making him demoting or discharging him from his service, or suspending him from service, or threatening him, or harassing or incriminating or discriminating him from others, those activities should not be done. So no partner or employee may be discharged. I will write it here. Because of that, he should not be discharged or demoted or suspended from the service or threatened, harassed, or in any other manner discriminated. So it is against the terms and conditions of the employee or employment, that is discriminated against the terms and conditions of his LLP or employment merely because he has provided this information. So because of that, he should not be, it gives protection to the person, whistleblower. So protection to the person who gives that information is called as the whistleblower. So protection is given to the whistleblower. Right? Is this concept clear? 31. Section 31 talks about whistleblowing. So first they may reduce 2 points. First, the court or tribunal may reduce or waive any penalty if a person gives a useful information and as a result of that information, the LLP or the partner gets convicted. Then to give a protection to that whistleblower who has given that information, he is protected. Because of giving that information, he cannot be discharged, demoted, suspended, or threatened, or harassed, or discriminated in any way. The next thing, contributions. So what is the contribution given by the partner? That we will see. It can be in money or any other equivalent of money, a property, a movable property, immovable property, or tangible property. It could be anything. So a contribution of a partner may consist of tangible, movable or immovable or intangible property or other benefit to the LLP, including money, promissory notes. Either he can contribute 5 lakhs and he can say within 6 months, I will pay another 1 lakh for your thing. So his total contribution will be 5 plus 1, that is 6 lakhs will be the contribution. He has agreed to contribute within 6 months. And within that 6 months, if the LLP is dissolved, then he is liable because he has agreed. So his contribution is only 6 lakhs. That has been tested in an MCQ. So that you can refer. So 5 plus 1, it is 6 lakhs. So his contribution, whatever he has contributed, and this he has agreed to contribute. Both will be his contribution. Including money or promissory notes, other agreements to contribute cash or property. To contribute cash means not yet contributed. He has promised or agreed to contribute the cash or property. Even that is also a contribution. Contracts for services performed or to be performed. So agreed, whatever he has agreed, that he is liable to contribute. Then he has contributed, no, that should be disclosed in the accounts. This 6 lakhs, this 5 lakhs will be disclosed and other 1 lakh it is liable. The LLP can show it as a liability. So that should be disclosed in the accounts. That whatever is his capital contributed. Like normally we do it, no, whatever is the capital contributed, that should be accounted for and disclosed in the accounts. Right? So it contribution can be monetary or other contributions and that should be disclosed in the accounts. That is the two things. Then what is his obligation to contribute? Section 33 talks about it. Now he has agreed to contribute. Then a creditor can force him to contribute. The creditor who based on this LLP agreement, now he relies on this LLP agreement, right? So this creditor has relied on this LLP agreement. Then this person has not contributed. Then this creditor can force this person to contribute. Force the partner to contribute because that has been provided in the LLP agreement that he will contribute. He can ask the partner to contribute that whatever he has agreed upon. So the obligation of the partner to contribute money or other property or any other benefit or to perform services shall be as per the LLP agreement. So it shall be as per the LLP agreement. A creditor of a limited liability partnership which extends credit. Who's a creditor? The supplier who has given the credit or otherwise acts in reliance on an obligation described in that LLP agreement without notice of any compromise between the partners. He was not aware, but he relies only on this agreement. But actual could be anything. But whatever he was not aware of that notice may enforce the original obligation. See, it is the original obligation. Subsequently, the partners have agreed and some change has been there. But he can insist on the original contribution which has been described in the LLP agreement. So that's why the word original contribution may enforce the original contribution that is there against such partner. He can enforce it. Is this clear? See, that you should have to see whether a partner has committed a fraud and his punishment is completed. If in certain cases they would have specified 5 years should have elapsed, then he can contribute. That you should have to see whether the provision, there is a provision for that, and only then he can join as a partner. Suppose it is not mandatory, if it is beneficial, then the LLP can take him as a partner. If it is beneficial, it was inadvertently done and he was punished. So it was not a mistake, but however it was done, it has to be taken, the decision has to be taken by the LLP, whether to take him as a partner or not. But if the law, subsequently, if the law says he cannot be admitted as a partner, then he cannot be admitted as a partner. Financial disclosures. So you are starting an LLP. Then what are the obligations, legal obligations that you should have to disclose to the people or to the registrar? So you have to maintain proper books of account. Then you have to file statement of account of solvency. And not only that, you will file also the annual return. Annual return should also be filed. That we will be learning. When you file this, you also file the annual return within 6 months from the end of each financial year. And statement of account and solvency shall be filed with the registrar every year in the prescribed form and by paying the fees. And audit of accounts is generally done. And if the central government may exempt, then it is exempted. We will see one by one what are the financial disclosures that has to be done by the LLP. So it is maintenance of books. See, when you maintain the books, it can be done on the cash basis or accrual basis according to double entry principle. It has to be done every year and the account should be kept at the registered office. So shall maintain such proper books of account as may be prescribed relating to its affairs for each year of its existence on cash basis or on accrual basis and according to the double entry system of accounting, and it shall maintain at its registered office for such period as may be prescribed. That you should have to maintain. This is maintenance of proper books of accounts. Then not only that, it should also file a statement of account and solvency within 6 months. So statement of account and solvency. Within 6 months from the end of each financial year. So if it is 31st March is the year ending, then on or before 30th September, it should have to file. As at the last date of the prepare, it should have to prepare a statement of account and solvency for the said financial year. Whatever is your financial year, you have to do it in such form as may be prescribed, and it should be signed by the designated partners of the LLP. The third subdivision talks about the filing with the registrar. In such form, in Form 8, LLP generally files this statement of account and solvency, accompanied by fees that it is doing. So this is preparation. Subsection 2 talks about the preparation. Subsection 3 talks about the filing with registrar. Right? Then it should be in accordance with, it should be audited. Then 4 talks about the audit. It is generally audited. However, an exception, the central government has power to exempt. By notification in official gazette. It can exempt from the requirements of this subsection. Then subsection 5 talks about the penalty for non-compliance. So if it is a continuing default, you have not filed the statement of account and solvency, it is a continuing default. So 100 per day for the LLP, subject to a maximum of 1 lakh. For LLP, it is more, 100, maximum is 1 lakh. For DP, because designated partner is liable for compliance, so 100 per day. For him, it is 50,000. And for non-compliance of subsection 1, 2, and 4, what is that? Maintaining of the books of accounts, or within 6 months you are not preparing and it is not audited. So in those cases, the LLP is liable and the DP is also liable. So for this, the LLP is liable for not less than 25,000. Minimum is 25,000. Maximum is 5 lakhs. For the designated partner, minimum 10,000. Maximum is 1 lakh. That is the penalty for non-compliance with the accounts. Then, accounting and auditing standards. This is the only place where NFRA comes into the picture. National Financial Reporting Authority. So the central government may, in consultation with NFRA, can prescribe the standards of accounting, the standards of auditing. So the central government, in consultation with NFRA, can prescribe the standards of accounting and standards of auditing. that it can recommend as per as recommended by ICAI. Then we shall see what are all the annual return. What is the annual return that it should have to file and what is the penalty. Whenever this word duly comes, it is very important. Duly authenticated annual return. So it should have to be signed by the designated partners. Everything should be perfect. An annual return in Form 11, it can be filed with the registrar. For annual return, 60 days time limit is there. 60 days time limit for filing with the registrar. If LLP does not file, then it is a continuing penalty. So for that LLP, it is 100 per day, subject to a maximum of 1 lakh, and for designated partner, it is maximum is 50,000. So for LLP, it is 100, maximum 1 lakh, and for designated partner 100, maximum is 50,000. Then inspection of documents. Who can inspect? Can that documents be inspected? Yes. The documents can be inspected. Whatever the registrar has, that can be inspected by any person. See, by any person, not necessarily by the partner, any third party. You can also inspect. I can also go and inspect. So any person can inspect what it can expect. As I told you, the incorporation document, the name of the partners, and whatever is the changes, they would have filed the various forms. Then statement of accounts and solvency, annual return. All these shall be available for inspection by any person, but of course on payment of such fee. In the portal, they can go and inspect in such manner and on payment of such fee as may be prescribed. It can be done by any person. Then, penalty for false statement. If any person specifies anything falsely, then he is liable for it. So what is a false statement? Suppose a company, an LLP is unable to pay its debts. It is going to be wound off. That you are omitting. A liability is not there. That is not given. Or anything falsely, you are saying you should have given it correctly, but you are not saying the correct thing. You are giving a false statement that it is okay, it is a going concern, or it will not be wound up. Then that is a false in material particular. It is when it is going to be wound up, you should have to intimate that to the person. So that is a false statement. If in any return, statement or other document, three things are considered here. In any return or any statement or any other document, any person makes a statement. It is any person makes a statement which is false in any material particular, knowing it to be false, or omits any material fact. For example, concealing the litigation is there, or liability. The liability is 5 crores or 50 crores, liability is there. It has not specified that in that statement. So all these examples. then he omits to bring that fact into consideration in that statement, then he shall be punishable with imprisonment, and shall also be liable to fine. So for imprisonment, minimum 1 lakh fine and maximum is 5 lakhs, and he is also subject to 2 years imprisonment. Maximum 2 years imprisonment can also be given. So it is imprisonment and fine. This fine can be minimum 1 lakh, between 1 lakh to 5 lakhs. It could be any amount. Then what is the power of the registrar to obtain information? So now it specifies the registrar's powers. He can enforce, no, what the powers of the registrar. To enforce the LLP to do an act. What are the powers? He can ask the LLP to answer any question or give any declaration. See, what are the things he can do? He can ask the LLP to answer any question or give any declaration. Or furnish him with the details. Or particulars in writing within a reasonable period. That he can ask. Whom he can ask? He can ask from any person, including any present or former partner. Present or former partner or designated partner or employee. So from whom? The question, from whom? First one, present partner. Second one, former partner. Designated partner. Even an employee can be asked to provide that information. Now the registrar has asked, it is the duty of those persons to give the information. Then he does not answer. The person does not answer within a reasonable time, or the registrar is not satisfied with the reply. He has given a reply, but the registrar is not satisfied. Then the next subsequent action, what is that? He has got the power to summon a person to appear before him, or an inspector or any other public officer. So to him, he can ask the person to give the answers, question, or give a declaration or details. So answer any question or give the declaration or furnish any details to the inspector or any other public officer which the registrar can designate. Or he can also summon the person. Summon means you should have to appear before him in person. Appear in person before him. That is called as power. He has got the power to summon also. Now, he has given the summon, but this person has failed to comply with the summon. That is punished. So, he has not complied with that summon, then not less than 2,000. So, minimum is 2,000 rupees. Maximum is 25,000 rupees. Fine can be levied without any lawful excuse. So in that case, this should be specified. Without any lawful excuse, then he is responsible for paying that fine. Yes, I will correlate this with section 10. Yes. See, even in section 10, you have read it. So that should also be read together. See, what you can do for penalties. Each one a penalty is there. You keep a separate, how you should have to read is that penalty, what are all the penalties from each section? You prepare a chart. You have to say what is that for this, what is the penalty, for this, what is the penalty. This is a confusing topic. So that you should have to read it, deal with it separately. What is the penalty? That if you spend some time and do it, it will be helpful for you. You have to work it out. What is the penalty and understand the provisions clearly. What penalty? Penalty chart. Yes. So for this alone, one day you take or for 1 hour you spend and read the penalty provisions alone for this LLP for 2000. What is the minimum penalty, maximum penalty? That alone you should have to do it. So here without any lawful excuse, he shall be punishable with fine which shall not be less than 2000 but which may extend to 25,000 rupees. Ah. We'll go to compounding of offense. Shall we proceed further? An important topic. What is compounding? If it is, you compound to avoid the prosecution. You compound your offense with the authority so that you will not be imprisoned. So you agree, you come to an agreement with authority that you will pay the fine, an offense punishment or an offense which is punishable with fine. So what is compounding of offense? When the offender pays a penalty to avoid prosecution, that is compounding. Yes, when imprisonment is there, it cannot be compounded. Exactly, Kuldeep. So the offender, what can be compounded? It is an offense which is punishable with fine only can be compounded. Meaning, if it involves imprisonment, that cannot be compounded. Then it cannot be compounded. A offense which is punishable with fine only can be compounded. Who can compound? The regional director or the officer not below the rank of regional director can compound the offense. What can be compounded? Which offense which is punishable with fine only. The sum collected may extend to the maximum amount but cannot be less than the minimum amount provided for in the offense. See, whatever has been minimum amount, maximum amount has been specified, no? That minimum amount that will be collected may extend to the maximum, up to the maximum amount. It can extend up to the maximum amount, but it can in any case cannot be less than the minimum amount. Suppose example, the minimum amount specified is 10,000 rupees. Then your fine can be at least 10,000, but it cannot be 5,000, 9,000, anything a lesser amount than the 10,000. That is the concept which has been provided. So minimum amount should be compounded. So that is there. Then application for compounding can be made to whom? Can be made to the registrar. And what the registrar does with his comments, he will forward with his comments either to RD or higher authority or any other officer not below the rank of RD. So he will forward his comment. Then if it is compounded, then they will do it and they will give the intimation within 7 days. Intimation shall be given to the registrar within a period of 7 days from the date on which the offence is so compounded. So if they have compounded that offence, that is, they have stopped with fine alone. If prosecution has been initiated for that offence, then what the registrar will do, he will give it in writing that it has been compounded, then the punishment for imprisonment will be stopped. So he can get a waiver from imprisonment, or he will not be imprisoned. You will see where an offence is compounded, no prosecution shall be instituted. Is compounded before the institution of any prosecution. Suppose the prosecution proceedings have started after. So is there any remedy? Yes. So what the registrar will do? The registrar will specify in writing to the notice of the court that the offender has compounded and hence he will be discharged by the court. So you have to take the thing before it is prosecution proceedings have been taken, has started, or by mistake prosecution proceedings have been commenced. You have waited, then you have to go and it should be brought by the registrar in writing. So for the purpose of compounding, the RD, the regional director or any other officer may by order direct any partner. Now he should have to do it now. So he should have to file the accounts return document by paying the additional fee. But if he fails to comply with this order, it is twice the maximum amount of fees levied as penalty. If he fails to comply with the provision. Imprisonment involved, it cannot be compounded, but it is the discretion. If it is involved with fine alone, if it is further worsened, it could be before the proceedings take. It can be, yes, we shall have a break for 10 minutes and then we shall continue. So up to compounding of offence I have taken. We will take a 10 minutes break and we will meet. Now it's 7:33. We will meet after 10 minutes. Or 5 minutes, shall we have 5 minutes break? By 7:40 we will meet. Yes. We will take a break. Okay. Yes. So welcome back. We will see we saw the compounding of offences, and it should have to be the registrar has got the power to specify that he can give it in writing so that the prosecution proceedings can be dropped for the offender. And if any partner, DP or employee fails to comply with the order, then the punishment or the penalty can be twice the amount of maximum fine. That is with respect to compounding of offences. Now we'll continue with assignment and transfer of partnership right. Now the question arises, if a partner has a right, can he transfer the right to any other person? The law says yes, he can transfer the right to some other person. So we will see what the act says. The rights of a partner to a share in profits and to receive distributions are transferable either wholly or in part. Meaning, he can transfer that to any person. Just because he has transferred, then that doesn't mean that he has disassociated himself from the LLP. So that will not constitute, that transfer will not constitute disassociation. He is still associated with the LLP. The rights are only transferred, but he is still a partner, meaning still a partner. Will not cause the disassociation of the partner, does not by itself cause the disassociation of partner, or dissolution or winding up of the thing. It will not constitute either dissolution of LLP or winding up of the LLP just because he has transferred the interest. That is the second proviso says. But he has transferred, no. So he is the transferor. Now partner A has transferred to, let me give an example. Partner A has transferred to X. This X cannot participate, this X cannot participate in the management. He is the transferee. So X is the transferee. The partner is the transferor. He has transferred his rights to X. X cannot participate in the management or conduct of the activities of the LLP. He has got no right or he cannot access any information concerning the transactions of the LLP. That is not possible. So the transfer of right does not by itself entitle the transferee to participate in the management or conduct or access such information concerning the transactions in the LLP. Then, this is with regards to assignment and transfer of partnership rights. A partner can transfer to any person, either wholly or in part. Then conversion, we saw that second schedule, third schedule, and fourth schedule. talks about the conversion of the LLP or converting into LLP. So firm, a private company or an unlisted public company can convert themselves to an LLP. A listed company cannot do so. So the registrar, on satisfying that the firm, private company or an unlisted company has complied with the respective schedules, that is schedule 2, 3 or 4. Schedule 2, 3 or 4. So this is for firm. This is for private company. Schedule 4 is for unlisted public company. Register the documents and issue a certificate of registration. Now, this firm is now getting incorporated as an LLP, or this private company is getting incorporated as an LLP. So an LLP is incorporated due to conversion. So in that case, you have to, the LLP has to register within 15 days of the date of registration, inform the registrar of firms or whatever is the thing, the erstwhile firms or the registrar is there, no? So LLP, this is LLP should have to inform the firm, registrar of firms or ROC about this conversion within 15 days. So the erstwhile partners or shareholders who are previously the partners of the firm or shareholders of the private company or unlisted company are bound by the respective schedules, namely schedule 2, 3 or 4 as the case may be, whichever is applicable to them. Now they have incorporated, they have converted that firm into an LLP, then it shall be called by that LLP name. Now, if LLP has been going by the name PQR, so PQR LLP, it is recognized and it is called by that name. It is specified in the certificate of registration. Now, what happens to the property? That property vests with the LLP. Whatever previously it was vested with the firm, private company or unlisted company, now vest with the LLP. Now all the three will vest with the LLP. Whatever is the case, that will vest with the LLP property. And previously you cannot have a firm and an LLP. So that has to be dissolved. So firm or company is deemed to be dissolved and removed from the respective register. For removing it from the respective register only, you are giving intimation to within 15 days that it has been converted into LLP. And so the registrar or the register of firms, in that case, the necessary changes will be made and the names are removed from that register, from the previous register. Then we'll go to compromise or arrangement or reconstruction. So if it is made, you can make an application to the registrar, or an application can be made to the tribunal. Application for compromise can be proposed to the tribunal. By whom? By the LLP or the creditor or the partner, or in case the LLP is going to be wound up, by the liquidator. First, application is made to the respective persons or made by respective person, LLP, creditor or partner of the liquidator. what is that compromise that has been proposed? Either it could be the LLP and the creditors or LLP and the partners. When that compromise is proposed, then the tribunal may order. It cannot just like that enter into compromise. So a meeting will be called. And 3/4 in value of creditors, that is 75% of value of creditors, our partners should have to agree to such a compromise. Only then it is valid. If 3/4 in value of creditors or partners agree to the compromise or arrangement, if sanctioned by the tribunal, then it shall be binding on all the creditors, partners, and the LLP. And in case of LLP going to be wound up to the liquidator, and the contributory should have to agree to it, or it is binding on them also. So first you are making an application, then you are making an arrangement between the LLP and creditors and LLP and partners, then tribunal on satisfied, and 3/4 should have to be consenting to this. Pardon? Page 76. Wait, I will change it. Now is it visible? Only 75 is visible. Right. Now is it visible? I'll share. So 76 is visible? Is it visible? Okay. Now if I change, is it there? 77 come? Okay. Yes. Okay. So the tribunal may by order, it can specify, it can order a meeting of the creditors, and if 3/4 in value of the creditors, that is 75%, agree to it, 75% in value of creditors agree to the compromise or arrangement, then it is binding on the creditors, partners, LLP, and the liquidators, as the case may be. Then the tribunal can order only if it is satisfied that the partners have disclosed what it should have to disclose. All material facts are disclosed. All material facts. These material facts include the latest financial position. Not only that, if there is any pendency of any investigation proceedings, that should also be disclosed. They can disclose it by affidavit or by otherwise. They should have to make a disclosure of all material facts, latest financial position, pendency if any, that also should have to be disclosed. Then the tribunal will make an order. An order made by the tribunal should be filed with the registrar within 30 days. So the tribunal makes an order. So first one, order by the tribunal. Then this is filing with the registrar. within 30 days. You have to file it within 30 days. That order should be filed with the registrar within 30 days after making that order. If you are not filing, if the LLP is not filing, then again penalty. For LLP and DP, it is 10,000 fixed penalty plus continuing default, 100 per day. This is a continuing default. And maximum is 1 lakh for LLP and 50,000 for DP. It cannot reach. You are adding this 10,000 plus the default continues. So if you add it, the maximum can be 1 lakh or for LLP and 50,000 for DP. Now, if the compromise is made to tribunal, then the tribunal may stay the commencement of any suit or proceeding against the LLP. Now, it has passed an compromise or arrangement. Now, so in that case, it may stay the commencement of any continuation of any suit or proceeding against the LLP because a compromise has been arrived at. So, till the application is disposed of, it can stay the commencement of any suit or proceeding against the LLP. That provision the tribunal can do, can stay. Then, next. When it makes an order, tribunal, what are its powers? It can supervise, power of supervision. Or it can give a direction. It can even ask them to modify that compromise or arrangement. That is possible. Then, if it is satisfied, if the tribunal is satisfied that compromise cannot be worked out satisfactorily, then either on its own motion, on its own, or on an application by any person, it can order for winding up of the LLP. So if it feels that this compromise cannot be worked out satisfactorily, then it can order winding up. For that, either it can do it on its own, or if any application has been made by any person, even then it can take it into consideration and it can order, make an order. It has got a power to order for winding up of an LLP, and such order shall be deemed to be an order made under section 64 of this act. We are talking about in 61, 64 has been specified. So we will see that. So winding up order can also be passed by the tribunal. So first application, it sanctions after getting all the material facts, then that you should have to file it with the ROC. The tribunal has got power to stay the commencement of any proceedings or suit against the LLP. Then it has got a power of supervision and direction, and it can ask the LLP to modify that compromise or arrangement. If it cannot be worked out satisfactorily on an application or on its own motion, it can order the winding up of the LLP. Then it can also, what are the provisions for amalgamation or reconstruction of an LLP? See, in case of reconstruction, the LLP is there, present, it is not dissolved. Only the structure is modified. In case of amalgamation, the original LLP is gone, is not in existence. It can amalgamate with another LLP and form a new LLP, or it can merge with an LLP, or it can, the existing thing, it may have a new LLP. So here the structure, the old LLP is gone and a new LLP comes into the picture. Whereas in reconstruction, it is only a modification. So that is the difference. If the application for sanctioning compromise or arrangement is made to the tribunal, in connection with the scheme of reconstruction or amalgamation of LLP, and under the scheme, the whole or any part of the undertaking, property or liabilities is to be transferred. Now, undertaking, property or liabilities. This will happen only in case of amalgamation. So in that case, another LLP, then the tribunal may either by the order or by a subsequent order, in this order or by a subsequent order, make provisions for all or any of the following matters. For 5 matters, it can make a provision. What are the points or what are the provisions that it can do? The tribunal may do any of the following. It can transfer. So first thing is transfer. The whole or part of the undertaking to the transferee LLP, to the new transferee, to the new LLP. Second case, it can continue the legal proceedings. Now, this transferor LLP is that transferee LLP. Now, it will continue the proceedings with the transferee LLP, the new LLP. One which was pending against the old LLP, the transferor LLP. Now, that proceeding can be continued against the new LLP. That is the concept. Then, third one, it can dissolve. It can dissolve the transferor LLP. Then it can, suppose if any person do not agree to it, then the tribunal should have to make arrangement for it. So what are the provisions? It should have to form a provision. So it has to make provision for those who dissent, who do not accept from the compromise or arrangement, it will make a provision for that. Then any other incidental or consequential or supplementary matters which are necessary that can be taken. So it can transfer, it can continue the legal proceedings against the transferee LLP, or it can dissolve without winding up of any transferor LLP. It also makes provision for dissenting persons, that is who do not accept from the compromise. Then it should also pass such incidental or consequential matters for the reconstruction. Then, what are the conditions for the sanction by the tribunal? Now, it can do so only after obtaining the report. So, only after receiving a report from the registrar, that it should not be conducted in a manner prejudicial to the interest of the partners or in the public interest. So, it should have to get the confirmation report from the registrar that the affairs of the LLP have not been conducted in a manner prejudicial to the interest of the public or of its partners. Then the dissolution of the transferor LLP can be made by the tribunal only after the official liquidator should also scrutinize the books and he should also make a report to the tribunal. Now, a thing has to be wound up. So the official liquidator should have to report to the tribunal that it is not being conducted in a manner prejudicial to the interest of the partners or public. That has to be ensured. Then, what is the penalty provision and what is the effect of this transfer? The property shall be transferred to the transferee LLP. And whatever is, when the property gets transferred, it is freed from any charge which was applicable, that is also freed. And LLP has to file the certified copy. See, whenever you get an order from the tribunal, the certified copy should have to be filed with the ROC within 30 days. You have to communicate whatever order has been received by the LLP, that should have to be intimated to the ROC by filing it properly. If that filing is not done properly, then the LLP and the DP is punishable with minimum of 10,000, a fixed penalty plus a variable penalty. So this is a fixed 10,000 plus continuing default. Whenever there is a continuing default, a minimum and maximum limit will be prescribed, which will not exceed for the LLP 1 lakh and for the DP it will not exceed 50,000. And remember, LLP cannot be amalgamated with the company. That is not possible. One LLP can be amalgamated with another LLP, but LLP cannot be amalgamated with the company. Shall we go to winding up? So when winding up is done, either it can be done voluntarily or involuntarily. The LLP itself, if it decides, it can do it. Or involuntarily, when the number of partners is less than 2 and it continues for more than 6 months. The other day, some students were asking, is it a ground for winding up? Now we are learning that the number of partners is less than 2 and the LLP continues for a period of more than 6 months, then it will be wound off. And one more thing, if it has not filed the statement of account and solvency or annual return for any consecutive 5 years. See, not filed statement of solvency or annual return for any 5 consecutive years. Financial years. So, for at a stretch, yesterday a student was asking, so at a stretch, for 5 consecutive years it has not filed the statement, then that is a ground for winding up. Then the LLP has acted against the interest of the sovereignty and integrity of India, or on any other just and equitable ground, the LLP could be wound up. Then miscellaneous provisions. A partner who lends money to the LLP has the same rights and obligations as that of a third person who has lent, no? So the same rights and obligations, even though he is a partner, for the loan or other transactions, as though a third person, whatever a third person right has got a right, that equal rights a partner also has. So as a person who's not a partner, a third person, so partner's rights, let me write it. Partners has got a right equal to the third person right. Whatever third person has got the right, the same right a partner also has. Then the central government may direct, you should use this word, direct, may specify, or if you use any other word, that is not correct. May direct that any provisions of the Companies Act shall apply to LLP with or without exception, modification, and adaptation as may be specified. Any document or return required to be filed or registered under this Act with the registrar is not filed or registered on time, may be filed or registered after that time on payment of additional fee. You have to pay for delay in filing, additional fee is levied. Delay in filing, additional fee is prescribed to be paid. And you have to file it. Now, if the partner commits an offense for the second or subsequent time, then it shall be twice the amount of fine provided. Similarly, for this compounding, that also we will see. If the LLP commits an offense for the second or subsequent time, for the first time, okay, it is agreeable. Second time, it will be punishable with imprisonment also, as provided. In case of fine, it shall be twice the amount of fine provided. Then one more thing. We shall see the distinction between yesterday some students were asking about the distinction between partnership and LLP, and that we will see now. What is the regulating act for LLP? It is bound by LLP Limited Liability Partnership Act 2008. Then for partnership firm, it is Indian Partnership Act. Then this Indian Partnership Act is not applicable to LLP, that we learned yesterday. Now this is a body corporate. LLP is a body corporate. So that's why it has got a separate legal existence, perpetual succession, and LLP alone is liable for the acts. It is liable. LLP itself is liable. Its assets are the assets of the LLP. We saw that in the previous session. Now, partnership is not a body corporate. It has got no legal status and it has got no perpetual succession. It has got a separate legal entity separate from its members, whereas here it is no separate legal entity. It is created by registration. Here it is by an agreement between the partners. Partnership agreement was there and that is taken care of between the profit sharing ratio and whatever interest or whatever they have agreed upon, that will be specified in the partnership agreement. Registration, is it compulsory? Yes. LLP should have to register itself and it can sue and be sued in its own name. Whereas here it is voluntary. Only the registered partnership firm can sue the third parties. When I talk about perpetual succession, death, insanity, retirement or insolvency of partner do not affect the existence of LLP. Members may join or leave, but LLP continues forever. But as here, it has got no perpetual succession and hence it cannot continue. Then you have to have a LLP, limited liability partnership, or LLP assets at the end of the name. But here there is no such guidelines. It can have anything. ABC firm or ABC associates, just like that it can have it. Liability to the extent of agreed contribution, except in case of willful fraud. Now here they are personally also liable. So even the partner's personal property is liable for the liability of the partnership firm. It is a mutual agency. This is one of the characteristics of LLP. Each partner can bind the LLP for his own acts, but he is not liable for the acts done by the other partners. He is liable only for his own wrongful or wrong act done by him alone, right? Each partner can bind the firm as well as other partners by his own acts. Designated partners, at least two should be there and one of them should be resident in India and who should have stayed in for at least 120 days. Here there is no such provision. For legal compliances, only designated partners are responsible. Others, you don't make him liable. Here there is all partners are responsible for all the compliances and penalties under the Act. Yes, 120 days. So one should have resided for stayed in India for at least 120 days, minimum of 120 days. It has been specified as only 120 days. Then annual filing, you have to file the annual statement of accounts and solvency and annual return every year. Here it is not required to file any document with the registrar of firms. Foreign nationals can become a partner in an LLP, but they cannot become a partner in a partnership firm. A minor cannot be admitted, whereas there the benefit is that minor can be admitted to the benefits of partnership. When the prior consent of the existing partners are obtained, then minor can be a partner of a partnership firm, but minor cannot be a partner of an LLP. Then what is the difference between LLP and limited liability company? So this is LLP Act, this is Companies Act. Persons who contribute are called as partners of LLP. Here they are called as members of the LLP. So for the first case, they are called as subscribers to the memorandum. Then subsequently, they are called as, when further allotment is done, they become members. Even on subscribers to the memorandum are members of the company. Their names will be entered in the register of members and they go by that name. Then it is governed by the contract agreement between the partners. It is regulated by the statute, Companies Act 2013. You have to have limited liability partnership or LLP. Here you can have it as limited and private limited company or private limited as the end of the name. There it is deepen. Here you have this designated partner's identity number. Here the company may have corporate identity number and the directors will have a director's identification number. Of course, DSE should have to be obtained by both for filing the documents online. So minimum is 2, there is no such limit. For private company, it is maximum is 200. For public company, there is no such limit. Members can be organization, trust, business firm or individuals. So here the members of LLP can be individuals or body corporate can operate through their nominees. The liability is limited to the extent of agreed contribution. Here it is on the extent of unpaid on the shares held by them. If they have paid it fully, their liability is nil. Now the business is managed by the partners and the designated partners are authorized to comply with the legal formalities. They take part of or they affect the compliance. Now the affairs of the company are managed by the directors who are elected by the shareholders. And minimum you have to have a 2 designated partner, whereas for a company it is private company, it is 2 directors and public company, it is 3 directors. See, this LLP is a new concept. Partnership, we have it for such a long period. So there are in practice, there are so many partnership than LLP. Now it is rising in LLP also. There are so many LLPs. Now I'll share the MCQs. We will quickly go through the MCQs. We saw these MCQs. What is the form used for reservation of LLP name, incorporating a new LLP and execution of LLP agreement? The reservation of LLP name. What is the clue? So many have given the answer. How be, see, reservation of LLP name, that is the clue. What is run? Run is reservation of unique name for LLP. That is the clue. Run LLP is a reservation of name, unique name for LLP. So the answer is D. It is run LLP, run FILLIP, then E form 3. There is no concept of no, that's why students will get confused. They will put it as form 1, form 2, form 3. That's why this MCQ has been prepared. See, for those who have got wrong answers, get it corrected. See, I use the word reservation of LLP name. So, reservation of LLP name when I have used, that is RUN. What is RUN? See, what is RUN? This is reservation of unique name. So I have asked you the question reservation of LLP name. So this and this will not come. There is no LLP 3 form. It is only E form 3. Now, so the answer is only T. So run LLP, reserve name unique LLP, replace the whole form LLP. So there is no LLP 1. This is not there. There is no LLP 3 also. So this is only the correct answer. Yes, D is the correct answer. Vishnu was appointed as the designated partner. I think we saw this yesterday. So he should have informed the registrar within 30 days of the appointment. It is not 1 month, it is within 30 days. The Act specifies it as 30 days. So you have to specify it within 30 days. So B is the correct answer, within 30 days of appointment. So here it is not 1 month. If when it has been specified as 30 days, you have to stick on to 30 days. If Ram is declared insolvent during his tenure as a designated partner, what will happen? Under the LLP Act, we saw this yesterday, he immediately becomes disqualified. So, he is immediately disqualified from becoming a partner. Yes. We will see those MCQs which we have not seen. The LLP shall maintain its books of accounts at the branch office, corporate office, head office, or registered office. MCQ 8. Two have given a correct answer. Generally, for any maintenance of accounts, it has to be done only at the registered office. What is registered office? It is registered, that address has been registered with registrar. If you want to keep the books of accounts at some other place, you have to get the prior permission. So normally at which place the LLP shall maintain its accounts? It is only at the registered office. It cannot be done in other cases. So registered office is the correct answer. Who shall sign the statement of account and solvency prepared by the LLP? By any one partner authorized in his behalf? By at least two partners authorized in the behalf? By all the partners? By the designated partners? So many are able to tell the answer correctly. I am happy. So it is by the designated partners. So this is the answer. 9, it is designated partners. What is the periodicity of preparing the statement of account and solvency by the LLP? Ten. For 10, what is the answer? Within a period of 3 months, within a period of 9 months, within a period of 12 months, within a period of 6 months. The answer is simple. Yes, many have given the answer correctly. It is 6 months. Within a period of 6 months. Why? What did I say? It is 31/3. Generally, the financial year ends on 31/3 of a financial year. Say if we take it as 25, then it should be filed on or before within 6 months from that. So 30th on or before 30th September, that has to be filed. The court may or tribunal may reduce or waive penalty leviable against any partner or LLP if it is satisfied that where any information given by a partner or employee, whether or not during investigation, leads to LLP or any partner or employee of such LLP being convicted under this act or any other act, such partner or employee of an LLP has provided useful information during investigation. Both the options are right, both the options are wrong. None of the above means both the options are wrong. Many have given a correct answer for this. So this is also a reason, and the second part is also a reason, right? It is C. This was specified in Whistleblowing, section 31. Wait. Are you able to see this? It was specified in Whistleblowing. Yes. So it is, both options are right. Then, whether incorporation documents, names of partners, and changes of any statement of accounts and solvency and annual return filed with the registrar can be inspected. Yes, it can be inspected by any of the partners. Yes, it can be inspected by only the government authorities and banks. It can be inspected only by the creditors. Yes, it can be inspected by any person on payment of prescribed fee. For 12, so all who have given the correct answer. It can be inspected by any person. That is why you and I can also go and inspect the LLP, right? So it was specified in section 36. So it can be inspected by any person. What is the penalty? Of course, this is a thing which concerns your memory. For that LLP, this provision, this penalty, you should have to remember. What is the penalty for false statement made by LLP in any return or statement or other documents? It should have to know the penal provisions. Either it is 1 year, 2 years, 3 years, or 4 years. So it is B. Yes, many have given that it is only 2 years penalty. Then circumstances under which a thing can be wound up by the tribunal. Yes. Which of the following is correct? Partner decides LLP be wound up by the tribunal. For a period of 6 months, the number of partners of LLP is reduced below 2. The LLP has made a default in filing with the registrar the statement of account and solvency or annual return for any 5 financial years. None of the above. So let me see. Actually, this is a tricky one. What does the provision say? Can the partner decide? See, the LLP only should have to decide. What are the different cases in which it can be wound up? First case, the LLP should decide. The LLP decides. Can the partner decide? So, I have asked it as partner. So, this is wrong. For a period of 6 months, is it for a period of 6 months? It is reduced below 2 and more for a period of more than 6 months. So, in the second case, it is more than 6 months it continues. Then, if it is continuing for more than 6 months by reducing it less than 2. So, this is also not correct. Then for any 5 financial years, what is the rule? What the act says? Did I not tell you for any 5 consecutive financial years? Consecutive means from 2000 to 2025, if you take, or if the company, the LLP was incorporated at 2000, then from 2021, 22, 23, 24, and 25, consecutively at a stretch, it has made a default. For any 5 financial year means in the year 2000, or it could be 2010, it could be 2015, it could be 2022, it could be 2025. This is wrong. Are you able to understand the concept? The act should have to be read clearly for you to answer the MCQs. Right? Random year is not applicable for any 5 consecutive years. So it is only D, none of the above. None of the provisions is right. See, in an examination, you will have that thing. Your mind may not work. So try to concentrate and read the question carefully. You might know the provisions, but in the examination, whatever you write, for that only marks are given. So you should have to ensure that you write it correctly. So it is only D, none of the above. In each case, there is a mistake. It is not that partner decides. It is the LLP which is deciding. So for more than 6 months, for any 5 consecutive financial years. So none of the thing is correct. Then take this, read this. When Anshul joined Educom Innovators LLP, he discovered that key compliance filings, including the annual return and statement of accounts and solvency, were pending. What is Anshul's liability as a newly admitted partner concerning these past compliances lapses? So what is the answer for this 15th MCQ? Many have given an answer. We will see. Answers differ. So first one, no liability for past complaints, lapses, since he was not a partner. Shares equal liability for past complaints, lapses, because he is no partner. Anshul is liable only if the LLP agreement specifies. Anshul's liability for past complaints is limited to his capital contribution. I get different answers. We will see the answer. It is A. How can he be liable? See, he has joined. Will any person join if already there is a lapse and you are made responsible for no part? You were involved in that. So he has got no liability for past complaints lapses since he was not a partner. So you should have to be very careful in answering, right? In the same continuation, in the light of Anshul's concern about the pending complaints filings, which of the following best describes? See, each one might be a answer relevant, but you have to select whichever is the best describes the responsibilities of the partners in Educom Innovators LLP regarding complaints with the LLP Act. Only the designated partners are responsible. All partners, including the new partners like Anshul, are equally responsible. Compliance responsibilities can be assigned to only one partner who will bear the responsibility. The legal advisor will be responsible. I think you can get the answer correct. So many have given the correct answer. So only the designated partners are responsible. That is why they should have to ensure complaints. See, DP, that's why they are designated as partners. DP is responsible for complaints. So only designated partners are responsible. Suppose in the given scenario, Educom Innovators fails to file the statement of account and solvency or annual return for any 5 consecutive financial years. Which of the following could occur? See, that is the ground which we saw. Remember the chart. Let me see whether you are able to answer this. First one, it could be wound up. Second one, takeover. Revocation of all partners' rights until filings are complete. The losses are shared equally by all the partners, irrespective of the profit sharing ratio. Everyone has done it correctly. It is a ground for winding up. What are the other grounds for winding off? One is if the LLP decides. Second one, if the number is reduced below 2 and more than 6 months they are taking, then if it is annual accounts is not filed for any 5 consecutive financial years on any other just an equitable ground, it can be wound up. You go through the chart. So it is maybe wound up by the tribunal. So this is the correct answer. Then, this is the situation, key scenario. Based on that, we will be doing the next 3 MCQs. DEF LLP is a well-established LLP engaged in providing consultancy services. It has 4 partners, A, B, C, and D, each contributing equally to the capital and holding an equal share of the profits and losses as detailed in the LLP agreement. The partners operate smoothly until partner A encounters significant financial difficulties due to personal business losses and decides to transfer his entire share of profits and losses in the LLP to Mr. X, an external investor, a third party, in exchange for financial assistance. Can partner A legally transfer their share of profits and losses to Mr. X? Can he transfer? Why? Should he become a partner? What does the law says? A partner can transfer to any partner. See the to any person. But only thing is that he cannot interfere. You remember, we saw that he cannot interfere in the affairs or the management of the company. I said it is any person. It is not specified as any partner. He can transfer it to any person. But it doesn't mean that that partner is disassociating himself from the LLP. That is not the case. Even though he has transferred his shares and share of profits and loss to any other third person, it doesn't mean that he is disassociating himself from the partnership, LLP. So he can transfer. Partner A can transfer in accordance with the LLP agreement. Yes. There is no such condition because the act says it is any person. Read the section carefully. Any person. He can transfer it to any person. It has not been specified as a to any partner. This has not been specified to any person. So that is the meaning. Any third person not connected with it. But he cannot involve in the management or affairs of the LLP. That is not possible. And the partner is also not disassociating himself. Yes, he can transfer like few conditions, like he cannot interfere in the management or affairs of the business. Thus, the transfer of partners A shares to X result in dissolution of LLP. Yes, no, yes, no. Why it is yes? Because transferring indicates disassociation. No, because that is not a ground for dissolution. Third, all partners must have to agree. Fourth, it is unless it is explicitly specified in the agreement. Many have given the correct answer because that is not a ground for dissolution. No. So that does not result in dissolution. Thus, Mr. X gain any right to participate in DFLLB's management or access its financial records. He cannot, or can he access the financial records? So tell me the answer for this. A different answer. Has he gained any right to participate or access its financial records? No, he cannot. The third party has got no right to participate in the affairs of the LLP. So 20B, he cannot, unless expressly allowed by the LLP agreement for him to participate. Yes. We will quickly go through the topics which we have learned. Yes. So in today's topic, we'll quickly go through it. We started from steps to incorporate LLP. Yes. Reservation of name, run LLP, then form FILLIP. Then we have to, the LLP has to find E-form 3. And eligibility, he should have subscribed his name to the incorporation document. Then we saw the relationship between partners, the mutual rights and duties. Any changes should have to be filed in Form 3. Then they can impose the obligations on the LLP if there is an absence of agreement, shall be determined as set out in the first schedule. Then cessation, it should have to be intimated not less than 30 days to other partners. He should have to give a notice. And this automatically shall cease. This is an optional. First provision is optional. Second provision is mandatory. Shall cease on death or dissolution or unsound mind or adjudged as an insolvent. Then moment he ceases to be a partner, the former partner will be considered as still being a partner, because the third party, unless he has given a notice of his resignation or to the other partners or to the registrar, does not by itself discharge the partner from any obligation which he has incurred while being a partner. So the former partner is liable for obligations incurred cessation, registration of changes within 15 days, then 30 days. You should have to intimate the change to the registrar. You should have to file it. Then when there is a contravention, there is a fine of 10,000 rupees. Then he is an agent of the LLP alone, but not of the other partners. Whether the other person has no authority, whether it is known or unknown, the LLP is not bound. Extent of liability of LLP, section 27. Extent of liability of partners in section 28. Then holding out, he is liable. Any person, but of course, if any benefit has been received, then the LLP is liable for the benefit, for repayment, for loan repayment, and so on. Unlimited liability in case of fraudulent intention. And of course, fine, and he has to compensate. Whistleblowing, we saw that in MCQ also. Contributions, he is liable for the contributions and he can get the money on his money back when he ceases to be a partner. Obligation to contribute. Financial disclosure should be made within 6 months. He has to maintain the books. That has to be filed within a period of 6 months to the registrar. And statement of solvency, that should also be filed. And penalty for non-filing or non-complaints. Section C, 3, subsection 3 separately, and 1 to 4, it has been specified separately. Then NFRA in consultation, the central government may pass the standards. Then annual return should have to be filed. Then inspection of documents can be done by any person, shall be by any person. So this by any person, you should have to remember. Penalty for false statement. Then the registrar may require, he can also summon. If you fail to comply with the summons, there is a fine for that. Compounding of offences to avoid prosecution and associated legal consequences, RD can compound. It cannot be exceeded. And one more thing, if he commits a similar offense within 3 years, then that offense cannot be compounded. You cannot compound that. That becomes a subsequent. It is not a first offense. It is a similar offense if it is done within 3 years. If it is done after 3 years, that is treated as a first offense. The explanation of section 39 says that if a LLP does a similar offense after 3 years, that will be treated as the first offense and then compounding is possible. That is a very important point. So within 3 years, it cannot be compounded. You have to face the consequences. Then our registrar can forward the same with his comments. Here 7 days. And he can stop the prosecution proceedings which is pending. If you fail to comply, it is twice the amount of maximum amount of fine. Assignment of rights. He can share the profits. Rights of partner to share of profits and to receive distributions are transferable either wholly or in part. So this can be done. The transfer of right does not entitle the transferee of assignee to enter into the management, to participate in the management of the LLP. So within 15 days, he should have to inform the previous registrar or firms that it has been converted. It will be deemed to be dissolved. See here, new LLP is incorporated. The old one is dissolved. Transfer takes place. So you have to remember like that. Compromise or arrangement. This I will explain. So first one, application should have to be made. First, an application has to be made. Can be proposed to the tribunal by the LLP or the creditor or the partner or the liquidator. By the liquidator, it is if the LLP is going to be wound up, where a compromise is proposed between LLP and the creditors or LLP and the partners. The tribunal may order a meeting of the creditors or the partners. You are making that compromise with either the creditors or the partners. So you conduct a meeting of the creditors or the partners. In that meeting, either 3/4 in value of creditors or partners should have to agree. So 3/4. of value of creditors, our partner should have to agree. That is 75% vote in favor. That is the to be obtained. So 3/4 should have to agree. It is not a majority, it is 3/4 agree to the compromise or arrangement. Then it shall be binding on the all creditors partners LLP and the liquidator and contributories for LLP bound up. Then when it can sanction that order? Only after satisfying that LLP have disclosed all material facts, the latest financial position. See, just like that, you cannot enter into an compromise or arrangement. See, LLP and partners also, it can enter into a compromise or an arrangement. It's not only for the creditors. With LLP can also make a compromise or arrangement with the existing partners also, it can make a compromise or arrangement. So latest financial position of thing, it can be done by affidavit or otherwise. Whatever order has been passed by the tribunal, that should be filed with the registrar within 30 days. If there is any non-compliance not filed, then fixed penalty of 10,000 plus continuing penalty. For that, maximum limit is 1 lakh for LLP and 50,000 for designated partner, because designated partner is the person who is responsible for complaints. Is made to tribunal, then the tribunal may stay the commencement of the proceeding against the LLP till the application is disposed of. Then it has got a power to supervise, it can give directions, it can make such modifications as it may consider necessary for the proper working of the compromise or arrangement. If the tribunal finds that it cannot be worked satisfactorily on its own motion or on an application of any person, may order for winding up of the LLP. This is also a ground for winding up the LLP. So this is an order under section 64 of the Act. What is 64? So that is the conditions under which the LLP can be wound up. So this is also an order, reason for winding up of the LLP. Then amalgamation and yes, reconstruction, internal structure is modified. Amalgamation, the existing LLP is wound up and a new LLP comes into the picture. So in that case, the assets can be transferred, can make provisions for all or any of the following matters. It can transfer, the tribunal can transfer, then whatever pending proceedings are there, it can be continued against the transferee LLP. Dissolution can take place without winding up, or make provision for any person who dissent from the compromise or arrangement and such other incidental or necessary supplemental matters necessary to secure the reconstruction or amalgamation can be done. What are the conditions when it will be sanctioned by the tribunal? So the first part, it deals with after receiving a report from the registrar that it is not prejudicial to public interest. Then second point, it can be made by the tribunal. Dissolution for transfer or LLP can be made by the tribunal because that is going to be wound off. So in that case, the official liquidator should have to scrutinize the books and make a report to the tribunal that it is not being conducted in a matter prejudicial to the public interest or the partners. Then penalty, the property shall be transferred to the transferee NLP, and if there is any charge that can be freed from the property transferred. And you have to file the certified copy of the order within 30 days. You have to file the thing. Then if it is not filed, then it is 10,000 plus 100 per day. And for LLP, it is one, let me share. So it is a continuing default. It is 1 lakh and maximum is 1 lakh for LLP and maximum is 50,000 for designated partner. It cannot be amalgamated with a company. Then winding up, if the LLP decides, so here the partner has got no decision. The LLP should have to decide. And here less than 2 for a period of more than 6 months. And for any consecutive 5 financial years. Then it affects the interest of the sovereignty and integrity of India. Then on any just and equitable ground, it can be wound up. And any person who lends money has the same rights and liabilities as a third person. Any partner who lends, he has got the same right as that of a third person. The central government may direct that any provisions of the Companies Act shall apply to LLP with or without exception, modification and adaptation. If a person commits an offense for the second or subsequent time, then the punishment shall be twice the amount of fine provided. Then we saw the difference between LLP and partnership. This is very easy, which you can do it. Any doubts, you can share your questions if you have. Else we will stop it and conclude the class. Yes. Thank you, everyone. Go through the provisions and try to read the question carefully during examination, what has been tested and what is your answer that you should have to write, that you frame and you think once or twice and then write the answer. Yes, thank you everyone, and we shall conclude for the present. Thank you. Have a good day. Yes.